Thank you. You can start. There are 24 participants.
24, is it?
Yes.
We will wait for some time now, Mansa.
We'll wait for a few minutes.
Yeah, because 24.
Good morning, everybody. This is Mal here. We'll just wait for a few minutes and then we'll start.
Second slides. Is this okay? Easily? Yes. Okay. No?
इनका थोड़ा बड़ा है. Comfortable सही है. चलो ठीक है. कुछ नया आया क्या? 25 minutes. Super. Hello. Okay.
Mr. Sengupta, I suggest you please start.
Good morning, everybody. This is Uttam Sengupta here. Am I audible to everybody?
Yes, you are.
Yeah. Very good morning to you once again. I am Uttam Sengupta here. I'll be your moderator today. A little background about myself. I have just retired as a corporate advisor on risk and contracts from Voltas Limited. I have been associated with CEI as its chairman of Western Region and governing council member at the apex body level. This being a small introduction to myself, about myself, I would straight away jump into to introduce our president, Mr. Dr. Ajay Pradhan. Dr. Ajay Pradhan is the president of CEI, is a civil engineer with a doctorate degree in water resource and engineering, and has a rich experience of around over 27 years on a number of projects funded by national and international agencies. He is the chairman and CEO of CETUS Consulting Solution Services Private Limited, C2S2, with its head office in Delhi. He is member of governing council of KIT and chairman of KIT University Academic Industry and Innovation, Chairman of Institution of Water and Environment India, Executive Member, Chairman of NCR and Delhi Chapter of National Solid Waste Management Association of India, recipient of Udyog Ratna Award, Water Leader of Asia, excellent. Member of Board of IIT, DSR, North Camp University, and many national and international agencies and academic institutions. Dr. Pradhan is also a mentor and an expert member of Information Technology Research Academy, ITRA Water, of Ministry of Information and Technology, Government of India, for IT innovation and research in water sector. It was excellent introducing Dr. Pradhan. I would like to request Dr. Pradhan to take over from me.
Thank you, Mr. Sengupta. Thank you for talking about CII's role and you being the moderator for very important aspects of CII, intellectual property rights. I welcome, good morning, and I welcome each and everyone participating in this CII's webinar. As I mentioned, it's a very important one for consulting engineer profession especially, which is on intellectual property rights. Let me thank my colleague at CII's Western Regional Center for organizing this webinar, Mr. A.P. Mal Saab, Jeffrey Nambiar Saab, Sengupta Saab, Dr. Harshvardhan Subarao, and many other colleagues for putting up a very good and right kind of a seminar, which is a little other side of engineering, but I think it's very, very essential for all of us to understand, especially when there is a data is emerging as one of the most important aspects in our business in day-to-day life. I think our friends also, colleagues at Western Regional Center organized also last month on June, hazards and risk, which was very successful. We had an excellent interaction and insight into our business aspects. Let me welcome our speakers today, which is an eminent speaker, is a lawyer and intellectual property rights attorney, Ms. Anuradha Maheshwari. I think Mr. Sengupta will give a brief introduction about her. I welcome her to be an eminent speaker for this session, and we look forward to hearing from her. Just to mention for our members, those who are joining for first time or maybe not aware of what is CII, Consulting Engineer Association is the apex body of consulting engineers in India. It represents the Indian engineering consultancy professional at the International Federation of Consulting Engineers, which is called as FIDIC. And many of you are all aware of the FIDIC contracts and other aspects. CII is the voice of consultant and consulting engineering companies in India. And it has a 60 years of legacy in managing and taking care of our the members and fraternity. And as I mentioned, intellectual property right, it is a property or intellectual property which is created through human intellect, like engineers, consultants, and many other professions, or creativity is one of the most important aspects of our business, and that's where we actually earn our money. Therefore, this kind of the knowledge is need to be embedded and need to be protected, not to be copied. It can be referred. However, it is inherent value that these things are short-lived. An idea and its application can, in many instances, be appropriated almost effortlessly, which is, I think you will hear. Proceedings without having proper mechanism in place can therefore be risky or dangerous. So therefore, we need to really look at how really to and essentially maintain this IPR. So let me give a very small example in my recent project, which has been frequently, countered by consulting engineers. Let me share you a couple of slides here so that I'll just make the context appropriate for everyone. So I hope you can see my screen. This is very recently I completed a project in northeast of India in Manipur state. The state, you can see, the state is actually 70% is hills, 30% is narrow valley, and every year you have gone through a severe floods, and you can see every flood is like this. This is one of the worst flood in recent memories. And this is Manipur state, you can see. And there is in the middle of this valley, there is a huge fat we call the Gahir. Hindi it is called Gahir part. Lamphel pet, which is like a marshy swampy land, which is kind of is a typical feature of the valleys. And you can see that this valley I just showed you from a very close picture from drone, all around hills, and there is a low-lying marshy land because of drainage congestion. And here in the middle of this is a huge land, almost more than 2,000 acres, and there is a sewage treatment plant, and there is a road cutting across here. This is whole area, and we want to convert, because to convert this marshy, not wetland, marshy swampy land into a kind of a water reservoir or flood moderation scheme of holding ponds or holding reservoirs. Thereby, you have to put some kind of structure to convert. And let me show you. And this is what would be like the lake area, and you can see the lake is spreading both the north and south side. And there is in the middle, which you see that there is also sewage treatment plant, and there's road connect. Therefore, to connect north south, we need to really put a bridge across here. Now this is very difficult. The terrain is not good. The soft soil, the hard soil come only minus 30-40 meter, so you cannot make any right kind of bridge. So we try to figure out what he wanted, something a nice fancy bridge to be putting across so that people can cross over. So we looked at, and this is what actually a bridge, which is a light and a steel structure. It's not a concrete, it's not a RCC. So therefore it is a lightweight, the foundation can be light, and people can cross over. With that also, they wanted also pedestrian bridge has to be there. And surprising, middle of night, I got this call. So I got out and got something and put it here. Then I found, my goodness, this is some European company has put it as copyright. So how can I use this? So copyright, structural engineers, and this is what prohibited for me. Although I made a quick calculation, looks like as a bill of quantities, but this is what actually I faced. Then I went back and found that this design is actually under the patent, and it's one part is patent, the other part is still approved by it is in not American, it is approved in European sector, but in India it's not approved. So I could use actually, but it's again violation. So this is where actually we come across with the people. With that, because why you need to put it, because there is a conservationist, there is an environmentalist, there are many others. They wanted to also see that we wanted light bridge, nice, and other aspect. This is one aspect actually which you see that we countered, and we don't know often that we use certain structure, even Google data. And this is another aspect here. You see, this is simple architectural of a network of a fraud forecasting system to put it here. And you see there are a number of sensors you need to collect. The sensors are, of course, you can buy, patented or you can softwares as well as the instrument. But if you want to use certain processes, it's been again the copyrights and your violation. This copyright actually I looked at, and I talked to some companies. They said this is a Japanese company who has done it, and this works very well in this kind of environment. So I talked to them. He said, yes, you mostly, but you have to also give us a royalty for that use. We'll help you to that. So these are two aspects I'm just mentioning, that how the consulting engineers often you use certain data or certain designs or network or the systems or processes. We quite often face this kind of a problem. So I just wanted to mention that these two aspects, so that we know what is IPR, how we are violated, where is copyright, where we write actually that this is protected, my document is protected for circulation of so many people. If somebody beyond that uses, it's again a violation. I think we need to learn those things from our friends. So therefore, I like to just ensure that whoever is doing design, consulting, even contracting in this field need to ensure that we also value those designs or processes and give due respects. That's one aspect. So I think I'm just going to talk big on the intellectual. I'm not an expert. We'll hear from our expert. With this, let me thank you all again, and I wish that this presentation, deliberation, and our expert knowledge sharing by Ms. Anuradha Maheshwari would be helpful, and we'll take forward some of those key aspects in our day-to-day business. Thank you very much, Sen Gupta sir.
Thank you, Dr. Pradhan. Thank you for giving a very brief introductory on the subject. It was really very insightful. With this, I would like to introduce our speaker today, and I'm privileged to introduce Anuradha Maheshwari. Mrs. Anuradha Maheshwari is a lawyer of many years and specializes in intellectual property, corporate, transactional, real estate, and human rights law. After years of experience in legal academics, she formed Lex Mantis, a legal service firm, in 2012, through which she helps her clients strategize their IP protection and advises them on their IP, corporate, and commercial transactions. Entity structuring where required, governance, compliance, due diligence, employment, and human rights related issues. So a varied subject that she covers, and it will be interesting for us to hear her today. She was recognized as one of the most powerful women IP in 2021 by World IP Forum, and also awarded the prestigious IP Star Woman of the Year at the Legal Era Intellectual Property Awards 2019. So gentlemen, ladies and gentlemen, a lot of accolades, both domestic as well as international, under her wings. Lex Mantis was recognized as one of the 10 most promising IP copyrights and trademarks consultants 2020 by Consultant Review magazine. In 2016, Lex Mantis received award for best practices in patents and IP excellence in India from Questel D Science Infoware and was declared as one of the most promising legal consultants of India by Silicon India in 2015. Anuradha, an erstwhile academician in SVKM's Institute of Intellectual Property Studies in Mumbai as its dean from 2005 onwards, and subsequently as its director under NIMS deemed university till 2012. She has collaborated with organizations like WIPO, Indian Patent Office, European Patent Office, USPTO, NASCOM, Music Producers Association India office, and is also with companies on various IP issues and programs. She helps to conduct various awareness programs on intellectual property and human rights. Gentlemen, ladies and gentlemen, you see, she has got not only an international, domestic, but an international fame under her wings. I think today her lecture would be very interesting and very useful to all of our engineers here. Thank you. And I would request Anuradha to take over.
This is also there. She continues to do it.
Mrs. Maheshwari? Hello?
Please unmute. Please unmute.
Hello, can you hear me?
Yeah, now is fine.
Yes.
Guys, we can hear you.
Thank you so much, Mr. Sengupta, and a very, very good morning to all of you gathered here today for this webinar. I must thank you that you have interest in this subject and that you have taken time out from a working day morning to attend this. It's my privilege and honor. I must thank Consultant India for giving me this opportunity and this platform. Dr. Pradhan, it was a privilege listening to you. Thank you so much for inviting me. Mal Saab, thank you so much for inviting me. Mr. Jeffrey Nambiar, and of course, Mr. Uttam Sengupta for this particular opportunity. As I said, this is a subject of passion for me. And I love to talk on this subject because each time while I speak, I learn a different facet and a different nuance of the particular laws that I am talking about. Intellectual property is so varied, so complex. It's just like an ocean. And for me to, to come before you all and to speak to you about this particular subject in the 1.5 hour brief that I have is actually quite difficult. So I will be just giving you broad and very basic insights to this legal subject. because obviously I cannot be talking the law with you all, but I would like to give you an insight as to what this particular subject is dealing with. So to begin with, I will start with my presentation. And I will take you all through the various aspects that are critical to this study of intellectual property right. To begin with, I am showing you all a very interesting thing, which I guess all of us have played with at some point of time, if I am not wrong. So there's no surprise here when I say that everyone here present would be knowing what this particular item is called. Yes, of course, this is called as a Rubik's Cube. Now, Rubik's Cube was very, very interesting. But before I go to the Rubik's Cube, just let me take you through the scheme of presentation that I will be following today. So I'm just going to talk to you about the value of intangibles. I'm going to talk to you about intellectual property and the kinds of intellectual properties that are there. I will touch upon briefly on patents, trademarks, copyrights, and designs. And then we will discuss the subject of data as an asset. The second part of the presentation will be about leveraging intellectual properties and what are generally, very broadly, again, I will not be able to get into great detail. Broadly, what are the strategies adopted by companies to leverage their intellectual property? So we begin with intellectual property and data assets. And as I said, we are going to look into Rubik's Cube. Very interesting toy that was made by one Hungarian and made at such a young age of 29 years only. Mr. Enro Rubik then went on to become a multimillionaire simply riding on this one small item called as Rubik's Cube. It's such a complex item, yet it looks so simple. Look at it, it seems stable, but yet it is dynamic. There are colors, there's a scheme, there is a pattern, and it is a mark of extreme intelligence. All of us have tried and failed. Of course, there may be many amongst us today who would have been able to successfully solve the cube. So it's interesting that this person was basically a sculptor. He was basically an architect. And he wanted to show something in 3 dimensions to his students. He thereupon fell upon this great, brilliant, earth-shattering idea, mind-boggling idea to create this Rubik's Cube. Of course, it didn't happen. It was not an eureka moment. It took him a lot of time to arrive at this configuration and to this particular cube. A patent for this particular cube was applied in 1975, and it was licensed to one very famous company called Ideal Toy Corporation, very famous in Europe, in 1980. First, they called it by another name, but subsequently, Ideal Toy Corporation thought that we should call it the Rubik's Cube. So there was a renaming exercise and it became famous as the Rubik's Cube. What is interesting to note is that within a few short years, over 350 million cubes were sold worldwide. So just look at the volume of sales that we are talking about. And of course, it became the top-selling toys, and world over, all kinds of Rubik's Cube tournaments came to be held. There was a movie made on it where it formed a central theme, which was Will Smith's Pursuit of Happiness. Anyway, the patent on this particular toy expired in 2000, and thereafter it came into public domain. But when it came into public domain, what happened was it became a benchmark for further innovations on this particular toy. What is mind-boggling, and that's why I say it's mind-boggling, is that there are 43 quintillion ways to scramble the Rubik's Cube. And each each permutation of that cube can be solved in 20 moves or more. So there's this entire science, there's this entire system, there's an entire mathematics to the way the cube has to be solved, and we reach a particular conclusion. But yet at the end of the day, it's a toy, and people spend hours together solving this particular toy. So what the entire exercise, I needed to also mention to you that 50 million knockoffs have been made on this Rubik's Cube. By knockoffs, I mean copycats. There are 10 million books on how to solve the cube. So the imitations, the bootleg varieties, etc., are still going on the Rubik's Cube. So this makes you understand one very critical thing. And that critical thing is that entertainment is very, very fundamental, very essential to our human lives. And therefore, entertainment is big business. And that's what I'm going to try and explain very quickly to you about the value of intangibles. How did we come across, or how did we come by this word intangibles? As I love to tell everyone again and again, that in the evolution of man, we find that man has come up with some brilliant inventions by which we are living today. Great invention of man has been property. Great invention of man has been God. Great invention of man has been a company. Great invention of man has been marriage. All these are constructs that have been created by man. So what really happened is, when the nomadic man started settling down, then the man started claiming the land on which it was settling down, or he or she was settling down. So the land came to be fenced, a house came to be built on that land, doors and windows were made, and the man said that this is my property. So man started claiming immovable property first. So immovable property, man, and see what we are trying to say over here, property is not natural. We are not really born with property. Why I say this is that people must not confuse inheritance of property as being born with property, though ultimately we tend to feel that we are born with certain properties. But honestly speaking, this is a man-made legal construct. So property is something not natural, but today it has become part of our lives, and we are living by the rules of property. Over a period of time, man started understanding that there was great value in things which are not touchable, in the sense that you cannot touch that thing. And they understood that things like reputation, things like a great idea which is successful and can be sold, can be called as a man's property. So over a period of time, ideas, ideations, innovations came to be called as intangible property. So the division between property is immovable property and movable property. Movable property again broke up into what is intangible property and tangible property. For example, if you look at stocks and shares, they are intangible property. We are trading in them. We can't even imagine our lives without a share market. And the share market is basically dealing in intangibles. So this entire concept of ownership to labors of the mind came to be a part of human lives over a period of time. So somewhere around 500 BC, we see the concept of intellectual property coming in. And today, of course, it is a very, very well-regulated and a well-entrenched system in the firmament of human lives. Of course, we also understand that entertainment is one of the biggest businesses of intangibles. So where you are looking at entertainment as a domain, as an area, we find that it is mostly dominated by intangibles. So I've just given you a kind of a snapshot here in this particular slide, where I am just, kind of taking you through the evolution of man in terms of man's ideas. So man's ideas first were restricted very specifically to tangible output. The tangible output, we call them inventions, and there were great inventions that saved the world. So we always say great ideas, great inventions is what made man survive as the largest surviving species, and is what has created this wonderful world that we are living in. So when you look at all these inventions, based on these inventions, then came certain innovations. So we look at the top innovations of all time, being internet, which is ruling our lives completely, dominating and ruling our lives completely. We have computer, we have light bulb, compass, semiconductors, written language. So somewhere around 3000, 3500 BC, we see evolution of the written language. And of course, we then have the wheel and axle, which are the milestones of evolution in human lives. But we have something even more interesting today, and that is great design thinking examples. Completely intangible. They are great concepts. The great concepts which have become bestsellers and over which great companies have evolved and are carrying on business. So these are some of those great examples: Airbnb, PillPack, CleanTip, IBM, Uber Eats, Zomato that we are seeing in India. Zomato's come out with an IPO. So some of the fantastic, and of course the last one, which I personally think is a great intangible in terms of concept, and that is Sulabh Sauchalaya, and how it has been a great successful model all over the country. So coming now to intellectual property. So what is that intellectual property, that intangible property that we are talking? So we are saying that you must have a great idea inside the head, but ideas cannot remain in the head. They have to be, otherwise there is no proof of that idea. So the idea has to be translated from pure idea to something tangible. So the first seed of the idea, the ideation behind the technology and the invention, which is there in your hand, but which now you can bring it down on paper, is the intellectual property of yours. So any creation of the human mind that can be locked in a tangible form is basically understood as intellectual property. Going further down the legal route, it means that it is intangible property and it is privately owned. That is because of the kind of state we are. We are a democratic country. In a democracy, we do not have public owned property. All property is not public owned. We are individually owning properties. But like all property, just like with your house, just like with your land, intellectual property can also be used, can be accessed, could be distributed, could be willed, could be gifted. We could do a variety of things, could be assigned, we could be sold, we can do a variety of things with the intellectual property that you own. Fundamentally, we have translated it from an idea into an asset. And that asset we have converted into property. So I may have a lot of assets, but I do not know whether I can legally claim that asset as an entitlement. Where I can legally claim that asset as an entitlement, that becomes my property. So everyone likes to protect their asset by converting it into a property that can be claimed at the end of the day. Now coming to a slightly tangential area. Everyone, as I said, would like to convert their asset into property. But what do we see in the world, and what have we seen over a period of time? One truth does not change. There is an universal truth, and that is, as human beings, as part of our innate human tendency, we love to copy. Copying is very natural to us. I can go a step further. We have also learned naturally to steal. It comes naturally. Remember one thing, the laws that we see today about stealing, about murder, about all kinds of laws, they were not in existence. These are all man-made rules, and over a period of time have become very well entrenched into your social and civil life. But earlier, these kind of rules was not there. So if you saw somebody eating bread and you didn't know what a bread was, you simply walked up to that person and you snatched it just like animals did. So stealing and copying was very, very natural to human beings. And I go a step further to see, were it not for copying and were it not for stealing ideas, human beings would not have progressed. Evolution would not have happened the way it happened. So there was some merit in stealing and copying, but obviously man realized that stealing and copying was not a healthy habit, especially if it deprived the originator of that particular idea from commercializing his idea. So let's say I am the idea who made the, I am the person or the inventor who made this particular toy, but somebody, my neighbor, comes to my house, he sees the process, he copies that, and he's a great marketeer and ends up selling the toy far more than I can. Ultimately, I get displaced from the marketplace. So this entire activity seemed very unfair. And that's how today we are talking about competition laws and we are talking about fair and unfair competition. So stealing ideas falls clearly plonk in the domain of, unfair competition. And I have given you some excellent examples over here of the kind of damage unfair competition does. What happens when you steal ideas? So in 2006, Ford company suffered a loss over 50 million after an engineer copied 400 documents into a hard drive and joined a competitor. This is the kind of example I'll be talking about today. US federal administration says that 520,000 counterfeit parts are installed in all aircrafts each year. Motor Equipment Manufacturers Association cites that 1 in every 3 auto parts are copied in the US. In India, auto counterfeits erode 30% market share with losses of INR 9,000 crores in auto component markets alone. Fake drugs constitute 30% of drugs sold in Asia, Africa, and Latin America, and has generated $75 billion in revenue in 2010. What I'm trying to say is fake drugs sold in the markets, and this is the kind of revenue it generated. Pfizer alone lost $2 billion in a year on counterfeit Viagra. We then come to design thinking examples, how fashion companies today are completely ruined by the fakes that are available in the markets, and how companies like Louis Vuitton, etc., are thinking about great ideas to replicate their fakes and sell it as genuine. So it's a very interesting example where Louis Vuitton has hired a street artist who they found was making fakes of their bags and said, okay, you have great ideas which are selling, obviously. So we will now have a premium market and a fake market where actually we are selling genuines, but people will buy it as our second line of products. So this is an interesting industry, the fake market, and we always say it's not that governments are not aware of the parallel fake economy or the counterfeit economy, but they do not want to do anything about it simply because it's an economy and it's adding to the revenues and giving people jobs. So the counterfeit industry is global and is 1.2 plus trillion. The fashion industry alone was the fake industry in the fashion sector was around 450 billion in 2018. Just to tell you what kind of issues are involved in the counterfeit market. So therefore, it's no rocket science to tell you that whatever you create, you have to protect it. Without protection, you're lost. You will get displaced, you will get thrown out of the market, and it's damaging to all the efforts. It particularly becomes damaging when there are huge companies who are investing huge amounts of money in R&D exercise, like pharma, biotech, engineering companies. So at least for them, for whatever inventions and innovations they are creating, they need to protect. And this understanding happened in the 18th and the 19th century, when from the European continent, people started making regulations on how to protect and govern intellectual property. So the first example is the Paris Convention of Intellectual Property, industrial property, which happened in 1883. Then we have in 1886 an international treaty being signed for protection of copyrights. And finally, we come to the very modern era in 1995, when we formed the World Trade Organization. And the World Trade Organization, in pursuit of the global demand for protection of intellectual property rights, enacted or passed what is known as an international treaty, which is famously called as TRIPS. So TRIPS is trade-related aspects of intellectual property rights, which sets the global minimum standards for protecting the intellectual property. So this is how it is sort of come to crystallize in today's world. Not to say that laws were not there in place. Laws were there in place, but now they are far more standardized and far more regulated, with WTO and TRIPS taking over. So very quickly, what is the constitution of intellectual property? So first is the ideation bit, where we create the intellectual property, we create ingenious ideas. The ideas are translated and transformed into a tangible output, but those ideas must clearly exhibit mental skill and labor. If we are asked to prove, especially when we are filing patents, please give us evidence of the mental skill and labor used in creating a particular idea and invention. That idea has to then be in such a shape that it can be considered as your asset. Any asset, again I'm repeating, is notional, and it is in the domain of intangibles. Like I said, shares, stocks, they are notional. But we are creating the property value around it by giving it an entitlement. All right, so there is documentation which, one second. There is documentation which clearly indicates that you are the owner of a particular share or a particular set of stock, and that becomes your entitlement to that set of shares or stock. So fundamentally, it is an intangible asset. It can be owned. It is of course valuable. Therefore, you are trying so hard to protect that asset. And why do you want it in the form of property? Only for one reason, and that is it is transferable. That was the concept of property that man created, that you should be able to transfer your property to your children, to your parents, to somebody you love to give, whatever, but it should be transferable, or else you just want to sell. Selling is a transfer. So that is what is done by this method of creating property rights around your intangible asset. So what kind of rights do we get? This much is the intellectual property. And from intellectual property, you get the intellectual property rights. Intellectual property rights is an umbrella term. It's an umbrella term talking about a bundle of rights that emanate from one single property. So it's just not one right, you get a bundle of rights coming from one patent, one copyright, one trademark. Fundamentally, these rights are broken up into two parts. They are positive rights and they are negative rights. Positive rights tells you that what you can do with these properties. You can sell it, you can exploit it, you can commercialize it, you can license it, all the things you can manufacture, all this you can do with your positive rights. negative rights, which is very important, and therefore intellectual properties are called as private exclusive monopoly rights. They are always referred to as exclusive monopoly rights, is that you can exclude anyone from touching your property. By excluding anyone, it means you can prevent anyone, you can stop, you can restrain anyone who comes to infringe upon your property. However, they are monopolies, but no monopolies are good for the marketplace. Monopolies tend to destroy the marketplace. Based on this understanding, the thought was very clear that we need to give monopolies to encourage the creator. The creator has to be encouraged to produce more. So what we are doing by giving him an intellectual property right is telling the creator, we recognize that you are the creator of this particular asset. And therefore, you alone should be given the right to exploit this asset. But because monopolies are not good, this right will not be given for more than a certain number of years. So therefore, the monopoly right is time bound. It comes with the tag that it will be available only for so and so time. Now, this particular slide, if you see, has been done to give you a picture of what are the critical or key intellectual property rights that are generally understood in the world today. So if you see this, one big area component is patents. Another big area is copyrights, but I have kept it slightly separate. Another area equally big is trademarks. A smaller area is designs, and even smaller area is the one relating to GIs. So let me quickly explain what they are. What does patents do? Patents only protects, I repeat, only protects inventions and nothing more. Patents are for inventions. They are granted for, they are a monopoly right granted for protecting your invention and your idea around that invention. What does trademark do? Trademark is protecting your trade identity. Whatever the method of that identity is, whether that identity has been created in form of a logo, in form of a design, in form of a shape, in form of a word, in form of alphabets, in form of numbers, they are all your trademark. For example, 555. 555 is 555 is basically the trademark of a cigarette. But it's so famous the world over, needs no introduction. So that is a trademark. We come to designs, and what does designs do? Designs protects the external appearance of goods. I will talk about it in a little greater detail. We then come to copyrights. Copyrights is the baby of the lot. It took a lot of time for the world to realize what is copyright, simply because the world did not read and write as much. So reading and writing was a new phenomenon in the lives of people. And when the printing press happened and communication became a revolution in the lives of humans, that is when copyright took off. And expressions, it is protecting only your expressions. So this, we go to the next one. Please give me a minute. So we go to the next slide, which is giving you now a composite picture of how many intellectual properties and what are the various categories of intellectual properties. So one of the easiest classification of intellectual properties is on the basis by which a country governs the intellectual property. So there are two methods to govern the intellectual property. One is that the intellectual property is so important and so prevalent in the marketplace that you need to create a body of rules and regulations around it. So we call them statutory IPs. So for example, to protect patents, we have the Indian Patent Act. For copyrights, we have the Indian Copyrights Act. For trademarks, we have the Trademarks Act. We have the Industrial Designs Act. We have the Geographical Indications Act, Plant Varieties Act, Semiconductors Act, and Biodiversities Act. However, all intellectual properties are not protected and recognized because of a law. There are certain intellectual properties which are over and above this, and they exist nonetheless. They are your ideas and they need to be protected. Lots of small time traders in the marketplace exist who often sell something which is quite well known in the marketplace. So sometimes if you go to rural markets and you look into the rural markets, you will find pesticides and insecticides are very often sold by certain prominent names, but those names are not trademarked. For example, TikTok 20. Now TikTok 20 is available. Everybody knows what is TikTok 20, but TikTok 20 need not have a trademark. So there could be what we call as unregistered trademarks. Similarly, lots of countries in the world have not recognized a trade dress. Now, what do we mean by a trade dress? A uniform appearance that a company launches for its brand or for its product. For example, Apple. Now, whenever you go to an Apple store or you buy an Apple product, they are typically in silver and white. White is the trade dress of Apple. The Panta purple is the trade dress for Cadbury. All Cadbury products are being sold in Panta purple color. So purple color is representation of Cadbury, that electric purple. So moment you see it, you go to a you go to a supermarket or you go to a mall and you suddenly find one shelf which is that purple in color. You don't even have to look, you know that this is the shelf relating to Cadbury products. So this is trade dress. One of the hugest areas today of common law IPs is data. We don't have anything specifically to say that data is protected in a particular through a particular law. However, the category of data may fall under any of these statutory IPs. Another big domain of unregistered IPs is the area of trade secrets. So I'll talk about trade secrets and confidential agreements or confidential information, which is another big area of intellectual property. Likewise, we have technical know-how, we have client lists, HR practices of a company, the methods of raw material sources, and India's biggest intellectual property, which is traditional knowledge. So traditional knowledge is also a common law IP, but of course, traditional knowledge belongs to a community or to the entire country or nation as people. So coming to a patent. Now, patent basically comes from the word on the face of it. So it is patented means it is a public declaration. It's an open notice which tells the world that a monopoly right has been granted to a certain inventor. So it's a bundle of rights with a title and a status granted to a patentee, the holder of the patent. Why does he get a patent? He gets a patent because he has invented something. And why he gets a patent for his invention? Because there is a trade-off. The trade-off is the government says, I will reward you with a patent, but in exchange you have to do something for me. Why should the government give patents to people without something in return? And what is the return that the government is asking for the patent? The government is saying, disclose your invention. So the government is going to give 20 years right to a patentee saying, okay, in these 20 years, do what you wish with your invention. But after 20 years, it will come into the public domain. And anyone in the public domain will be free to make or manufacture or copy that invention. So public knowledge is enhanced. It will then become a benchmark for further innovation. So this is what is done by a patent. However, One of the most complex laws we say is the patent law. And one of the hardest things to be granted is a patent. It takes a long, long time to be granted a patent because the examination process is very long and arduous. The person who gets a patent has to be truly deserving to get that patent. So government has a lot of criteria, not only our government. This criteria is laid down by TRIPS, is there in almost all countries in the world. And the criteria is that your invention should qualify as an invention. When what we mean by that is it should be an invention as understood. For example, now let's take turmeric. Turmeric is known, the properties of turmeric is known in India. It has been documented. It's part of our traditional knowledge. And someone comes out with a cream to say that this is an antiseptic cream, give me a patent for it. You can't get a patent because this is not an invention. This is traditional knowledge. So when we say you are saying it is an invention, the law says, please prove that what you are calling an invention is really an invention, is not a discovery. That is one of the things that we have to prove. Second, the law in India has also gone a step further to lay down specifically what kind of inventions would be permissible in the eyes of law. I'm not getting into it, but whole law and the famous 3D section is part of section 3 lays down what invention is patentable in India. All right. Apart from that, if we cross that hurdle, we go to the next step, which is the most important step as far as invention is concerned, is that you have to prove that your invention is novel, that there is nothing like this in the world. You are seeking a patent in India, but novelty has to be worldwide, global. So we do a global patentability search to say that there is no such invention anywhere in the world. That is not to take away from the rights of the inventors anywhere who would want to invent the invention subsequently in India. Okay. We then come to the next important step. If you recall, when I told you that you have to prove every time that there is mental skill and labor attached to your idea. So that is why we have to prove inventive step. So inventive step is the heart and the soul of the invention. Please prove what you have done to create that invention. And the last but not the least, please prove that it is applicable to human lives. It has some value and that this invention can be reproduced through an industrial process. So industrial applicability or utility is the next step of invention. Come to trademarks. I've already given you something about it earlier. It's a visual mark. It's a sign. And sign is anything that conveys information. So whatever you choose to adopt as your trademark, it should be capable of graphical representation. So therefore, I'm going to read out what is a trademark. Trademark means any device, brand, heading, label, ticket, name, signature, word, letters, numerals, shape of goods, their packaging, like I said, in trade dress, or any combination thereof. All right. Today we have a whole new area of trademarks, new IPRs as some of them are called, and that is unconventional trademarks like smells, like colors, etc., which can be registered as trademarks. The most interesting thing about trademark is that while technically the monopoly right on the trademark is given for 10 years, you can keep renewing it. So it is possible for your trademark to live for 200 years, 300 years, because you are renewing it every year. So these are the functions of a trademark, as we call it. There is only one critical function of trademark, and that is to distinguish your goods from your competitor. So distinguish goods and services of one trader from another trader. But in the process, what else it does is it identifies the product. It also gives you information on from where exactly the product is coming and who is the producer of the goods or services. It also, as it grows famous, it also helps you to advertise your product. So it's a great marketing tool, the trademark. And further down as we go, what it also does is it assures the consumer of a particular quality and a product sort of standard. So for example, when I'm buying Surf Excel, all I need to do is look at the trademark and I know that I have got a certain quality of product. So one thing which I always tell everybody that you should remember is um, um, is that the more unique name that you find, the more unique will be your trademark, and better will be the public retention and recall of that particular trademark. Copyright, as I said, is the baby of the lot. Basically, to do with written words, that's how it started. And it came from the literal meaning of the right to copy. So it says that copyright does not mean the right to copy others' work, but it is the right to copy your own work. So what we are trying to therefore say is only you, as a creator of any work, have the right to reproduce that work. Reproduce that work, amend that work, revise that work, put the work out in a different format altogether. So, for example, I write a television play. I can take that script and make it into a stage play. I can take that script and make it into a film. I can do what I wish according to my desire to reproduce the original writing. All right. So, essentially, it is the author's right to copy her or his own work. When somebody else copies your work, then it is what we call as plagiarism. Plagiarism is copying something which not you have created, but somebody else has created. Object of copyright is to encourage authors, composers, artists, and designers to create original works and to reward them. So these are all the areas where copyright exists: literary works, dramatic works, musical works, cinematographic films, sound recording, computer programs. Design is external appearance. It is because of designs that companies like a Mercedes Benz or a BMW or an Audi or your famous watch companies or your famous clothes designers are making. So the idea of the shape, configuration, pattern, ornament, composition, lines of color are all what is captured in your design. It should be about the external appearance of a set of goods. We call it external appearance of an article of manufacture. It should be aesthetic. It should be beautiful. Ugly designs are not registered. So it's very, very interesting that, today so much talk is happening, let's say, about spare parts of planes and cars. Today, if you open the bonnet of a car and look inside, though it is the internal portion of the cars, but each part has been made beautifully. So debates are arising whether we should consider them as internal parts or external parts. So they too, the idea is, can they be sold individually in the marketplace? And if that is so, then the external appearance of those articles which are part of the internal part of a car will also be considered as part of design. There is only one requirement over here. The design has to be novel and original. So I repeat, in the case of patents, the requirement is your invention has to be novel and your invention should have an inventive step and be useful. In case of copyrights, your expression should be original. In case of trademarks, your marks should distinguish your mark from a trader's mark or a competitor's mark. And in the case of designs, the external appearance has to be novel and original from what exists in the marketplace. So this is design. We come next to trade secrets. Big area of intellectual property. There are so many processes, there are so many things in the world today which are kept as trade secrets, and the company's success is riding on the trade secret. Famous example, Coca-Cola. Coca-Cola's formula is a trade secret. though I'm sure that it has been reverse engineered, and I'm sure that people have come very close to figuring out the exact composition of Coke. Otherwise, we would not have similar products in the marketplace like a Thumbs Up and a Pepsi, etc., etc. But nonetheless, it is a formula which is a well-kept trade secret. So like that, you have Kentucky Fried Chicken, you have Listerine formula. So many such things are there which are well-guarded trade secrets. And the company's performance is riding on these trade secrets. However, there is a catch in this. It's all good till the secret lasts. The day the secret is lost and it becomes public, the IP is lost. The intellectual property on the secret is lost. So trade secrets can be any technical, non-technical data, a formula, pattern, compilation, program, device, method, technique, you name it. Whatever you choose to keep a trade secret becomes your trade secret and your intellectual property. Okay, we then go to a kind of a picture of a Nescafe was to give you an idea of all kinds of intellectual properties riding in this particular one bottle. So you look at the cap and you look at the shape of the bottle. It's a wasted shape, and therefore the design is, there's an aesthetic appearance to the design of the bottle, and there is a design. I don't know whether there's a registered design or not. You look at the granules. The granules, if you look at them very carefully, they are hexagonal granules. They are extremely dry, and they remain dry in the bottle because they have been created by a freeze drying process. So there is a decaffeination done by a freeze drying process, and this is a patented process. This is trademark Nescafe, Blend 37, a cup of character. All these are trademark. The whole picture as a whole is a copyright. So you just look at all of this and you find a whole bunch of IPs riding on a single bottle. I've done very quickly to give you timelines for intellectual properties. They are alive for how long as your intellectual property. Patents, as I already mentioned, 20 years. Trademarks, I've already mentioned, 10 years, plus every year of renewal. Copyright lasts for the lifetime of author and 60 years in India. In the US, it lasts for lifetime of author plus 90 years. In European Union, it lasts for lifetime of author plus 70 years, so on and so forth. So therefore, you have different kinds of copyrights in photographs, cinematographic films, broadcast reproduction right, performers' rights, and I have given what these copyrights are. Industrial designs, again, varies from country to country. In India, we have it for 10 years, and a renewal is permitted for another 5 years. So total right is there for 15 years only. All right. So we come to organizational assets. Every organization has so many assets, one more important than the other, that it is very difficult to say that this is the most important asset. However, there is one asset that is being undervalued, and people are not knowing about this very well. So we have first asset, cash and financial instruments that the company may have, the real property, the immovable property, the inventory, which is the movable property of the company, the intellectual property, which I have just talked to you about. We have the human capital of a company. So its people is another property of the company, again, in terms of intangibles. The financial assets of the company, the stocks, the shares, the bonds that a company may have, which is again the financial property of the company. Then we have the reputation and goodwill. Reputation and goodwill is extremely difficult to determine, is something on which the company is riding, because if you really look at it, this entire thing about stock markets, when you see a stock is going up, you're saying share prices are rising. There has to be a justification for the share prices rising. Very often, you see that the share prices rising in a company is not commensurate with the company's performance. The company's performance could be lackadaisical or could be just about average, but the share prices seems to be soaring. And the share prices could be soaring on, rumors, on a certain reputation, on a goodwill that the company has garnered in a certain way. And that becomes the overall brand of the company. So brand is both a trademark term as well as a marketing term. So when I say companies like Hindustan Lever or Unilever, they have a brand. Of course they have a brand. It needs no introduction. So it's so huge, the brands of these companies, that anybody will buy any product of this company and will not need to test that product. That is the reputation of the company. The largest area, again, which I said is undervalued, is data. Today, data has become humongous, absolutely uncontrolled in terms of the data that is flooding the companies. And the companies are often clueless how to value this data. Now, data can be something in terms of content that is created, something in terms of digital asset that is created, something in terms of tangible assets that is created. So when earlier companies, they used to have files and files of data that was tangible. Today we have files and files of data, but which is stored electronically. So that becomes our digital asset. The issue is that these intangible assets ride on two things. One is reputation and the other is recipe. The recipe is the intellectual property. The reputation is the brand. So every day, newer and newer forms of data are being collected. So people are collecting data to find out your preferences. People are collecting data on how a particular set of operations are being done, what is happening in a supply chain, what is exactly taking place in a supply chain, what is being done when the product is delivered, what is being done when delivery is happening. For example, it would be mind-boggling to understand the kind of data that platforms like Swiggy and Zomato have. The delivery data that Zomato has, it could start so many parallel businesses with the preferences of consumers that they have studied over the years. So most enterprises, however, think that to monetize their data, they have to sell it. But there are companies like Netflix who do not wish to monetize their data or sell that information to other companies wanting to ride on that information. All right, what they prefer to do is to enrich the cinematic experience of its own consumers. So the Netflix is watching what you're watching, when you are watching, what are your keywords when you are searching, and it is using that knowledge to throw back to you what you should watch next. It is understanding your preference and is now telling back to you algorithmically what you should be watching next. So they are engaging with their consumers. So like, for example, I, as a person, I find it very difficult to move from Netflix to any other platform because I find it so easy, so user-friendly. So I find it connects with me the way it engages with me. So that is a different kind of an experience, and that's how you build, brand loyalty. So they are using that data not only to monetize. Look at the humongous data that telephone companies have and how they are selling it to marketeers and marketing companies. So you are inundated day in and day out with calls from marketing companies selling their products. So builders, real estate companies have all tied up. And they are what data are they taking from telephone company except the telephone numbers? So that is some of the most interesting thing, that how people are, or how companies are increasing shareholder value by monetizing and protecting their data. So we come to the most difficult part, and that is value of data. How to value? One of the nicest examples that comes to mind is about 5 of the 6 biggest companies, that is Apple, Amazon, Alphabet, Microsoft, and Facebook, who are by market cap valuation the biggest in terms of brands, and they are all in the data technology business. So companies who really understand the data or the big data that is there today and leverage it with advanced technologies are able to see continued growth. So see, for example, what Google, Alphabet Google, is doing with its GPS navigation. What's really doing is using crowdsourced review data about places. So people put up their reviews, and if the more the people review the places they go, the better Google, this GPS navigation becomes in throwing information about that place to you. So you are using GPS, immediately you put in your feedback to GPS, and it will give a better user experience to someone after you who is finding something more about that location. So innovators are using big data as competitive advantage to introduce efficient practices in the company. So for example, they want to predict consumer behavior. So Starbucks could be using or may be using RFID chips on the cups or the mugs that you use to drink the coffee. So for example, unknown to you, you're drinking the coffee and there is that RFID chip which has noted down what coffee you drank, at what time, how much you drank. All this information is then going to be used by Starbucks to understand whether there is one particular brand of coffee which seems to be more liked by people in the world or in a particular territory. Indians like Arabica, some other countries like some other coffee. So all this data will be collated to analyze consumer preferences, to predict consumer behavior, and it was only going to make their cash registers ring better. So what has emerged now is a new technique, and this technique is called as prudent value approach. As I'm saying, there are no hard and fast rules in the game. Valuation is anybody's guess, and these are valuating intangibles which are very difficult, and they will be linked, correlated to what the real business is doing, what it did in the past, what it is doing in the in the present, and what it can do in the futures. So numbers will be ascribed, and this is how mergers and acquisitions take place. So a certain brand gets valued, and the approach that many companies, especially in the US, are adopting is called as the prudent value approach. Basically, a way to measure or value data based on the extent to which it has been used or leveraged to make business decisions in the company, the key business decisions in the company, and they put a number to that. I come to very quickly 2 or 3 case laws. This case law is Z Telefilms and Sundial Communications relating to data. Sundial Communications was a maker of content and cinematic programs, all right? So they made various TV shows, various films, short films, advertising films, and they then sold it to buyers of those cinematic content, right? They were in talks with Z Telefilms to buy their product called Kanhaiya. So Kanhaiya was a concept, and as they engaged with Z Telefilms and the negotiations kept going on, they started giving even more details about the plot called Kanhaiya. Kanhaiya was then subsequently made into Krishan Kanhaiya, and the details were provided in the form of the detailed plot, character sketches. The pilot was written and submitted to the defendant, but suddenly all fell silent. There was no response forthcoming from the company, and then they dropped the idea. They then decided to ask Sony Television to buy their concept. When they went to Sony Television told them that, boss, this is being produced by Z Telefilms already on the floors, and they are likely to start the episodes, airing the episodes. That's when they got wind of what's happening in Z. They checked and they found that the entire concept and the pilot that was written by Z was being copied by written by Sundial, was copied by Z, and Z was putting out a show which was purely pirated. So the judgment went in favor of Sundial. The court held that whatever Sundial did was absolute original work, and that Z had copied large or substantial portions of that work, and therefore they ordered an injunction, that is a restraining order stopping Z Telephones from continuing with the process of launching Kanhaiya. Another case was Diljit Titus, very interesting case. A lawyer who was a sole proprietor firm had some of his senior associates working with him. The senior associates were working on a lot of files. Then they kind of crossed and there was tension in the office. So that senior associate, that is Alfred Adabert, along with a few others, left the firm. When they left the firm, they copied a whole lot of stuff that they had worked on and they took it with them. Diljit filed a suit against them saying that that was my copyright and you had no business to take. The court sided with him and said that it was his copyright because he was the proprietor. And what they did in that company, even though they had done the work, they did it as employees of the company. So they had no right to take that work. I also dealt with a case like this, and this client was in Singapore. Client started a completely new EdTech platform. The platform was to enable people in South Asia and Southeast Asia, parents of students, to get admissions to colleges in US on the sports quota. And they hired this young dashing boy from Delhi, very smart boy. The boy did good business with them, helped them, sort of grow. And then suddenly he started playing truant. Then one fine day he says, y'all are not giving me enough. So they, quadrupled his salary. Then he says, let me think about it. And then finally he says, sorry, I'm not going to take it. And he left. Now, while he was leaving, the company was in the process of signing up with another sports candidate. And they suddenly realized that the sports candidate and he had tied up together. Like that, this boy ended up taking 3 of the company's candidates. And that is when we wrote and we got the boy to stop his activities, which were, he just stole all the data from the company, all client information, methods of doing business, everything he stole. So he got an edge when he started in the marketplace and was able to get a head start simply by stealing data from another company. So this is just to give you a quick example of the kind of issues that are emerging today with respect to data. So storing the data, managing the data, all of them are critical aspects of valuation of data. So when, like example, there's another kind of case that has come before me where I'll have to value the kind of trademarks the company has. So when we are valuing that, we are trying to look at how efficiently they have managed their trademarks. So we have to see whether they have replied to the registry in time, whether their marks have lapsed, whether they have paid in time. All these are part of management process. So the valuation of the data begins with you. How important or how critical you think that data is to the company and to you, and how you are storing, managing, updating that data, how you are following all the processes, legal processes with respect to the upkeep of that data. So come to this particular topic called as leveraging IP. You have the data with you. Now you should know what to do with that data. So one of the wonderful examples that I often give in my classes is talking about Kodak as a company. It's very interesting to just show you the graph of this company from zero to pinnacle, and then they came crashing down simply because of mismanagement within the company of their intellectual properties. What a fantastic stable of intellectual properties they created, and then kaput, one fine day, everything goes wrong. All right. So the company was founded, I'm sure many of you know this, that it was founded in 1883 by George Eastman. In 1888, the first camera was launched with the slogan, "You press the button, we do the rest." In 1900, a consumer camera for $1 was created called Brownie, which became America's bestseller. so on and so forth. 133 years the company was in product development. However, the personal business of the company, including 105,000 kiosks world over, souvenir photos at amusement parks, and photographic paper, is now owned by UK pension fund. So the company had to sell out. What happened? The company copied a patented product of Polaroid. So somewhere in the 80s, that is in the early 81, 82, Polaroid became a sensation because of their instant photograph camera. So you shoot and immediately you have to load it, just like you load it with film, you had to load it with paper, photographic paper. So as soon as you click and you click on the photograph, take print, and a photograph rolls out, just like you get a studio print in color. And it was a beautiful, amazing experience to have that Polaroid camera. Kodak then thought about it and said that why can't we, they lost out on this advantage and said, why can't we do the same? So Kodak came out with their instant camera with the instant photograph. Polaroid was a small company as compared to Kodak, but they got good legal advice and they were advised to sue that company. This battle went on for, court battle went on for 9 years, totally 14 years that this litigation took. And Kodak in 1986 had to pay almost 1 billion in damages to Polaroid. They had to lay off 700 workers, shut down 1.5 billion manufacturing plants, buy back nearly 16 million instant cameras, which were sold between 1976 and 1985 at the cost of US 500 million. And the legal fees for this battle went to US 100 million. So obviously Kodak keeled. And it was a big, big blow for Kodak. So litigation along with other mistakes. And while the world was moving to digital technology, Kodak did not move so fast into the digital space. So they failed to adapt to the changes, the technological changes, and they had to file for bankruptcy in 2012. So they still own around 7,500 patents, and their most valuable intellectual, this word Kodak is the best trademark in the world. So the most valuable trademark is Kodak, and they still hold their brand, and which is now kind of saving them. The company today concentrates on selling printing equipment and services to businesses, and that's what it's doing. Similarly, all of you must have heard of the very famous, most watched television show on TV, that is Game of Thrones. It became a sensation in the world, but importantly, apart from being the most watched show, it was also the most pirated show for 6 consecutive years. The author George R.R. Martin had written a very famous book called The Song of Fire and Ice, and it became a sensation in the US. That is when, see, this is what intellectual property is, that eureka moment, the ideas. This is when 2 producers in HBO said, why can't we approach George R.R. Martin and ask him to adapt this book for television? They approached George R.R. Martin, he accepted, and the rest is history. So HBO reportedly spent 1.46 billion in the making of the GOT series. And in the process, they earned more than twice that in revenues. So just see what kind of an intellectual property they have made and how it has reaped them. Today, with babies, alcoholic beverages, gaming products, merchandise, everything is named on the HBO Game of Thrones names. All right. So this is a quick snapshot to tell you what George R.R. Martin earned from his very fantastic book, Song of Fire and Ice, and what he earned from HBO and what HBO earned. So George R.R. Martin earned royalties from publication, 10 million, HBO series, 15 million, Song of Fire and Ice print, 19.5, sale of GOT mass market paperbacks, which was 1.3 million, over and above about which he was given an annuity by HBO. That is every year, depending upon the profits, there was some profit sharing with George R.R. Martin. And then we come to what HBO has earned. So from seasons 1 to 8, they earned 3.12 billion. From CD sales, 168 million. From merchandise, 132 million. From subscription, $10 a month for 50 million subscribers. So you can do the math of how much HBO earned. These are the trademarks of HBO, which they have licensed. They have licensed trademarks to fashion designers, for T-shirts. They have licensed it to high-end shops for their slogans and catchphrases. Locations like Iceland and Croatia and Ireland became popular destinations and tourist spots for travel, and where all Game of Thrones names were being used. Johnny Walker has introduced around 10 GOT-inspired whiskey bottles for their consumers. So what we are therefore looking at is basically a transfer. This transfer we call as a technology transfer. There are various methods to that technology transfer. One is the hardcore technology transfer. The other is the methods of licensing around that technology transfer, where you would, along with the technology, transfer the trademarks that would be related to that technology. So we have, basically a transaction that takes place. And that transaction will obviously have 2 or more players, or it can have 3 players. So when I'm talking about transaction, the best example that comes to mind about technology transfer is what we are seeing today. When we are looking at the COVID vaccinations, and we are looking at the Covishield vaccination in particular, we are looking at the Oxford AstraZeneca vaccine. What happened here? So Oxford was the research lab. The research was funded by AstraZeneca. So AstraZeneca, the funder and the researcher, the patent is taken. So I am the researcher, the patent will be assigned to AstraZeneca. So it is an Oxford AstraZeneca patent. The researchers of Oxford will get named as inventors, and they will hold the patent. The patent was then exclusively licensed to Serum Institute in India to manufacture the vaccine. Exclusively in India. There's no other institute or no other manufacturer in India to manufacture the vaccine. So they would have done that for other territories also. Now, just say in the case that Serum is not able to make that vaccine more, then Serum can sub-license it to another contract manufacturer in India. But everyone has to keep everyone informed. So see the number of players in a particular transaction. So there are so many players, and it basically refers to the exchange of rights relating to ownership, possession, authority, etc., etc. Right? So technology transfer agreements typically are related to acquiring a newly invented product, or transferring the methods, the processes, or the modalities for production for this particular product, buy the necessary goods, raw materials from the inventor or the licensee, or import them, distributing, taking distributorship for the distribution of the particular product in the domestic and international market. So technologies can be transferred by registered patents, copyrights, utility models and designs, know-hows, confidential information, classified data, tech services, and support. There are, of course, new age computer software like data and computer software, semiconductor chips, which can also be transferred as part of technology transfer. So technology transfer is a business transaction, a business decision, and has 2 components: a context, a background of that business decision, why that business decision has taken place, why A company decides to engage with B company, what is B company's expertise, what is B company's specialty, because of which A is engaging with B, and then what would be the parameters, the contract, what would be the parameters of that engagement, which is what we write in a contract. So there is a context and there is a content, which is both captured in the agreement. All right. We come to kinds of technology transfer. We find purchases of equipment, machinery, and plants are all examples of technology. The biggest area of transfer of technology contracts come in the form of licensing contracts. So you can license in or you can license out. So I have a technology, I license out. I have a manufacturing capability, but I do not have the know-how, so I license in. All right. So exactly what Serum Institute is doing. So it has licensed in the technology from AstraZeneca, and it is manufacturing the vaccine in India. All right. So licensing is one of the best ways of technology transfer. Why we encourage license? License is any day better than outright sale. Once you go in for an outright sale, you lose the ownership and possession of your technology. But with licensing, you can keep the ownership of the technology. You may lose possession of it, but the point is you can engage with multiple players in multiple territories, provided, of course, you have taken patents in those multiple territories or protected your intellectual property in those multiple territories. As I said, sale is an outright transfer of your property. But where we come to an assignment, what we say about assignment is it can be limited or it can be for a unlimited period of time. Now, unlimited period of time means for the life of the intellectual property. But limited is like, for example, just the other day we did an assignment. So there was some confusion between a promoter of a company and the company. For some purposes relating to his finances, he did not want to show that he owns the patent. Or there was another example where the company was being acquired, but the patent of that company was held in the name of the promoter. So very quickly, the promoter decided to assign the patent to the company. So patent is getting transferred from the promoter to the particular company. The company will continue to hold it. And at another period of time, the company can further assign the patent to another player or reassign it back to the original player. So all these permutation combinations are possible. A huge area of tech transfer is joint venture agreements happening all the time. So two separate companies decide to collaborate. They will contract and there will be some amount of equity that will get transferred in a commercial sort of way. The technology is acquired. So typically, if you look at franchise agreements, they happen in this particular way. So if you look at McDonald's, biggest example of franchise operations, you have KFC, another good example of franchise operations. So many famous hotels and restaurants in a particular city or place in India, which then open up outlets all over India. That would be a franchise. Starbucks, what a wonderful example of a franchise operations. So there, what is happening? You are looking for a franchisee, and this covers both joint venture agreements as well as franchise or distributorship. Now, why distributorship? Because, like for example, in a McDonald's case, there was one person who took the franchise for entire India. All right, and he set up all the outlets all over India. But I hope you understand that to set up outlets all over India, he himself was entering into joint venture agreements with different people all over India. So these are some of the ways. And finally, turnkey projects. As engineers, I don't think I need to explain turnkey projects to you. You all would be very familiar with turnkey projects, where an entire plant and design is taken over, technical operation, and as a comprehensive arrangement end to end, start to finish. And once it is completed, it is handed over. So these are the kinds of technology transfer agreements or the methods of leveraging your intellectual property. Very specifically, when we are looking at legally, these are the terms we use for leveraging, licensing, franchising, strategic alliances or partnering, branding, merchandising. Merchandising is such a huge operations. For example, Universal Studios. All right, for example, MGM. All these huge studios, they make their money not only from the films, but the brands riding on the films. Let's take Harry Potter. One name, Harry Potter. And so many different articles were created from that one Harry Potter. We have flying frisbees, we have leaping frogs as chocolates, we have different items, pencil box, bags, umbrellas, every kind of merchandise is riding on these famous trademarks. So that's what I just gave you an example of Game of Thrones. How the names used in Game of Thrones have become so famous. They have already taken more than 100 trademarks, registered trademarks on all those names. Harry Potter, they have more than 500 registered trademarks on all the names that have been used in the book and in the films. And on all those names, brands have been created and merchandise products have been created. So, huge area of revenue is merchandising. Another area on which I have written about, and that is raising bank loans on IP collaterals. It's coming of age, not a very prevalent practice, because at the end of the day, it is an intangible, and banks are not very comfortable with intangibles, though banks do take shares and stocks, and you're allowed to mortgage them. But saying that I'm mortgaging my patent, I'm mortgaging my copyrights, not very heard of, but it is picking up everywhere, and at least trademarks, etc., are getting hypothecated in India. All right, we come to securitizing your finances through the same thing, like through methods of keeping your IP in store and raising money on them. Mergers and acquisitions is one of the best way of leveraging your strategies. As I just gave you examples of the kind of data some of the companies are collecting, and how there are people and companies all over the world clamoring to buy that data. So instead of that, one of the areas I would just show you mergers and acquisitions. IP litigation, I have not done a slide on it, but mergers and acquisitions, I'll just show you. But IP litigation, just to let you know that humongous amounts of money are being invested in fighting legal battles. And the outcome of the legal battles are damages running to billions and billions of dollars. So many such examples, and it's an exercise that a company decides to take only after weighing all the options. But it's now become another source of revenue for the company. All right, we come to IP transactions. So in 2014, there was a company called Osterhout, which was bought over by Microsoft. The company had 81 patents, and the price paid by Microsoft was 150 million USD. In 2014, Bayer was Global Foundries, and they bought IBM Microelectronics, 16,000 patents, and the price paid was 1,500 USD. Like that, I have given you all the examples. And like, for example, Apple bought Intel, 17,000 patents. But what is very interesting is the very recent purchase by Microsoft of LinkedIn. And what was the LinkedIn data? The LinkedIn data was the LinkedIn's connections. Just like a telephone company, you are buying LinkedIn's connection. Complete intangible data, which is bought over. Microsoft paid a whopping amount of $26,200 million as the price for buying LinkedIn's data. So if you just look at it, there is, like, I've given one last example, that is Amazon. As it's became big news, Amazon has bought MGM. I mentioned MGM to you. Amazon has bought the entire stable. You just see what Amazon is becoming. It has bought 4,000 films, 17,000 hours of TV, and multi-million types of data that Amazon would be having. That MGM would be having. All of that Amazon has bought for $8,400 million USD. Now, the question that has come about is, did Microsoft pay more for LinkedIn? How do you value that data? So these are the issues that are coming up again and again. Very complex issue. I don't want to get into it, but all of this involves an IP strategy. So the question that we begin is, do you know what you have created? And do you know how to manage it? Do you know what are the rights that have to be protected? So it is very important to formulate the right kind of IP strategy in the boardrooms. Important also for IP owners to demonstrate to their board and to their peers and to their colleagues and to their bosses the tangible value of their IP that they have created. So how do I demonstrate that? I have to show how the market perceives that IP, how the market values that IP, and what is the price that the market is willing to set for the IP. So the most efficient way of doing that is to establish an internal licensing program. Every company should have that, and they should be able to have mechanisms for setting licensing practices in place. Outsource to third-party licensing organization, sell patents, leverage patent pools, find out platforms through which IP brokering can be done, and they will help you sell your IP. So these are some of the ways to create these strategy. With this, I think I have covered most of the brief that I had today on how to manage your intellectual property and your data. With that, I will come to my last slide. And I would like to read out to you something that I love reading out wherever I go, which says that to create, I came across this in a book, and it says to create something from nothing in all the natural world is a uniquely human ability. Using our minds, we originate works of art, generate inventions, accumulate knowledge, and discover truths about the world we live in. What sets the information age apart from prior periods in history is the price tag we put on these intellectual creations. So with this, I would like to call it a day. And I thank you so much for patiently being with me for this particular presentation. I would welcome any kind of question that you would have.
Thank you, Anuradha, for the inspiring lecture. It was very educative, knowledgeable, so much of information that you have given us. Probably I also came across this information for the first time. Thank you very much. There are a lot of questions which have come up, Anuradha.
Yeah, do you want me to take them one by one?
Yes, yes.
So Sanjay Chaudhary, you have asked a question. In engineering, can a formulations concept improving the feature of an existing one be patented? So my answer to that question is it's too broad. We have to know what is the existing one that is there. And let me just, for the sake of your answer, presume that there is an existing technology already in place and somebody is innovating on that existing technology. Now, what the law says about that innovation, that the innovation should show a technical advance over the existing technology. It just cannot be something which is obvious. If it is obvious, it will not be patented. I am not from the field, but I will try and help you with an example which is very trite, but nonetheless, I find it very relevant. So for example, I know 2 plus 2 is 4. I know 4 plus 4 is 8. And I create a technology which says 8 plus 8 is 16. Now, this technology is obvious. Everybody knows that 8 plus 8 is 16. What you have created, if you create 8 plus 8 is 20, then we will say that you have innovated. 8 plus 8 is 16, everybody knows that. So it's obvious. So where the patent office, the registrar office, finds that there is some obvious element in that technology and it's not rocket science, then the technology will not be granted a patent. I hope that answer
I-
this particular
It's
question.
very lucid example that you have given, Anuradha. Very lucid example.
Thank you. Thank you.
Can we take the second question?
Whether the presentation can be shared with the participants. I don't know what's the practice.
Mr. Mal, can you please?
Yes, we will share it later on. No issues about that.
We generally put it on website or as PDF.
Okay.
Oh.
We then come to Girish, and he is asked.
No, the third question is Parthasarathi Sengupta.
I'm
How
not,
to know?
oh, I'm seeing
How-
Girish, who says you mentioned IP existed since 500 BC. Kindly mention
Yes.
instances and examples. Very many examples are there. Even in India, we had lots of examples of IP existing. Even Mohenjo-daro, Harappan civilizations have thrown up archaeological evidence of trademarks existing. The potters used to mark their stamp, they used to brand it. However, the example in 500 BC is in Greece called Sybaris, and it was a kingdom, small kingdom, and this is the first known instances of a patent where the king was so delighted with the recipe of a particular dish that the king granted the maker of that recipe a 1-year patent, giving him a monopoly only in the kingdom to make that dish. So these are all examples of monopoly rights. So even in the modern world, it started from 1421, where the first known patents were given to Venetian paintings, Venetian glass, and thereafter it was given to boats that were made for riding on the rivers. Come to Mr. Anuj Kumar Ghorpade. If a person is one of the inventors of a patent, also he is a founding member of a company, is it possible to that company to take licenses of that patent for commercialization? I actually touched upon this problem, the same thing. So there are two ways. It depends upon the person who has the patent, whether the person wants to license it to the company or not. Typically, if he is a promoter, then the ideal thing would be to assign it to the company rather than license it. But one has to look into the way the company has moved around the patent of the promoter, and based on that, the company can decide how to go forward, whether to take it on a license basis or to take it on an assignment basis. Sarvesha, should we apply separately for each component? Oh, yes, they are all separate registries. There is a copyright registry, there is a trademark registry, there is a design registry. The design registry is headquartered in Kolkata. The copyright registry is headquartered in Delhi. The patent registry is headquartered in Bombay. So all these, the geographical indications registry is headquartered in Chennai. But the main patent office is what we are seeing in Bodhik Sampada Bhavan in Bombay. All right. So this is the way they are all separate intellectual properties. There is a separate law for each of these intellectual properties, which I have already mentioned to you. How is the value of a patent measured? Is it arbitrary or there are some guidelines? No, it's not arbitrary at all. There are some guidelines, and generally people follow the cost approach, the market approach, and the prospective approach of to what the patent could actually bring in terms of revenues. Royalties are calculated, all of them are calculated. So there is accounting principles are structured and are laid down for valuing a patent. All right. Patent is far more easier to value than data, because there's a lot of intangibleness around surrounding data. So it's easier to value patents.
Few more questions.
Thank you, Mr. Girish, for your compliments. I accept it. Feels very happy to read whatever you have written. Thank you so much.
Few more questions are here.
Yes.
One gentleman, Mr. Sengupta, has asked how
Yes.
to know whether there is already a patent on my new idea. How to check prior art search.
Yeah, so we have a system called as a prior art search. Now, what we do by a prior means what is there previously. Art is knowledge. So by prior art search, what we do is we check global databases all over the world. So how do I check global databases? The only way I can check global databases is to go into the registries of all the countries. So for example, we go into USPTO. For example, we go into EPO. So we go into all the registries in the world and we type and carry out a very systematic search. From this search, you come to know what results are thrown up, and you come to know how many kind of inventions are there in that field. So sometimes we get data which is like 16,000, 17,000, 18,000, 25,000, and we keep narrowing the search words till we come to that specific data. And that's how we come to know whether there is an invention close to what your idea is.
The next question is how to make the patent application process by IPR legal advisor economic.
What? Sorry, I'm not getting it.
How to make the patent application process by IPR legal advisor economic. I think he wants to know how to make a patent application.
Yeah,
Yes.
so patent application, we have a particular form in which you have to put in the entire detail of the invention, who is the inventor, to whom you are assigning the patent. There are fees. The government, in all these registry, there are government fees separately and legal professionals fees separately. So the government charges processing fees. So if you are an individual, you can file the patent for 4,500. But if you are a large company, then your patent charges would be separate. So these are, I mean, you have to go through the patent agent who will guide you through the filing process. Every information is available in the IPO, that is the Indian Patent and Trademarks, Designs and Geographical Indications Registry. And you will find how the details will handhold you if you want to do it alone. Will handhold you as to how to carry out the application.
Thank you.
Elaborate. There is an aspect to that application which is writing the patent document. The patent document is a very large document. It's going into 50, 60 pages with details of that invention. And then you attach it and file that application.
Thank you so much. There's a last question, one Mr. Amitabh Ghoshal. Even every consulting firm or firms like Apple gain in value depending on the IPR of its staff members. However, when the consulting firm is sold, the money goes to the owner and no benefit to the employees. This is unfair just because they have received salary. Is there any protection or right of the employees?
So the only way I can answer this question to you is, I think somewhere there is, and I cannot comment on it, but typically I want you to understand this. Every inventor by law is entitled to a royalty, which is nothing to do with his salary.
Basically, I think the ownership comes into the play.
Yes. So if I am an employee of a company,
Ownership is not an ownership holder of anything. How can he get the benefit?
if I am an employee of the company, then whatever I have invented will go to the company. The company will own the invention. I will be known as its inventor. However, for having made that invention, I am entitled to a share of the profits that the company makes when commercializing that invention. That
Perfect.
is typically written in your contract letters. Many companies do not adopt that policy, but as a warning to people who are part of any R&D sector of any company, you have to see that your employment contract carries these details and that you will be eventually getting a benefit out of the commercialization of the invention. So even when the entire IP goes, there should be a benefit to you. If it has not been written, then obviously you are not going to get any entitlement to that. So these are some of the things that we have to be aware of, and we have to take the first step to, towards ensuring those returns.
Thank you so much for answering all the questions so briefly and with a lot of clarity.
Thank you.
Uttam,
Yeah.
There's a Dr. Krishnamurti who would like to speak and ask something. So he will raise his hand and then Mr. Maini will give him permission to speak.
Kindly, please go ahead.
Doctor, please go ahead.
Am I
Raja
audible now?
Krishnamurti.
Yeah, okay. I'll take just a few minutes. I know my video is not visible, but I think you can hear my voice.
Yes, is loud.
It doesn't matter, I guess. I have 3 inventions in Singapore, 1 in India, 1 trade.
Sorry?
Okay.
Your voice got disturbed.
Now he is visible if you want to.
Yeah, now. Yeah, please continue.
Yes. Okay. Anuradha Maheshwari, God bless you.
Thank you so much, sir.
Complicated subject. You could have gone on for 2 more hours. But I want to save my time also. Number 1, as I was saying, I got 3 inventions patented in Singapore,
Yes.
1 trademark, 1 patent in India, and 1 copyrighted transliteration of Sanskrit in English in India. Now, that's not very important, but I have had some unusual and some unpleasant experiences in the process. I'll mention only 2 without describing them. I published a paper in a journal from my own research and study. They didn't pay me anything. I liked the publication. It's one of the top publications. Then I wanted to put the paper into my website. They wouldn't let me. They said I had to pay a lot. I know the laws depend on various countries and so on, but I was shocked because I got nothing out of publishing the paper. And in my own website, I could not put it. That's number 1. You probably cannot answer that, but I'm just sharing.
I can tell you what happened.
Okay. Second, I was in a court case as an expert witness. And as I was coming out, the paparazzi, the newspapers, took a video of me and published a quote from my testimony. Next day, I wanted to simply quote what they said. Just take a screenshot, and my picture was more handsome than I appear. So I thought it was nice and put it, asked them to put it out of courtesy. You know, before I do anything, I asked them because of my experience. And they said, no, you cannot do that. You got to pay $78 per insertion. Meaning, it's a blurred line. Other people kind of exploit. I'm not complaining. I'm just sharing it with the audience that it's not as clean cut. Sometimes the inventions are exploited, and as you rightly said, unless you got a contract, unless like a film star, you cover your face and refuse to show your face to the paparazzi, then you're stuck with some of these. So at least 2 examples.
Yeah. So the whole issue is that the paper owns that photograph. So by law. So they have the copyright over it.
But it's my image.
It's your image, but you don't have the copyright on it.
I know.
The copyright goes to the photographer and the paper for which he is working.
Yeah.
So
I accept it, but it sounds unfair.
That's what I said. It's such an interesting and fascinating area of law.
Yeah.
And to share with you, just like your experience, I too had an experience like this of my paper. My research paper was published in IIT Bombay, and it's something that was an oversight on their part. And one of the first articles we are seeing was in a very famous government organization. A researcher from there copied the almost entire article and it was put out. So the article number 1, it was of that particular organization, and then it was mine. And we were all stumped seeing this. And
one last 30-second comment. I spent nearly $50,000 in trying to patent something which had already been patented in Singapore. And I had a lot of problems convincing the lawyers, and you know how it is. I won't go into that.
Yeah.
And the fact was that after 2 years of negotiations and claim definitions and so many iterations, a week before the final decision had to take place, the government withdrew with a kind of a statement saying software-based inventions of technology will be suspended. And I lost the whole thing.
Oh
So
my,
what I'm trying to say is the IPOs from different countries also are in flux.
yeah. So this is territorial laws, which is what I always say. There is no absolute uniformity.
Yeah.
There are minimum standards between the laws of various countries.
Yeah. Thank you, Ma. I enjoyed, and I hope you have a long exposure and sharing. Just like I hope I'm 90 years. I don't have much more.
It's a pleasure to meet you. You made my day today. Thank you so much.
Thank you. God bless.
Jeffrey, how much time do we have now?
You can ask if there are any other questions.
Another 10 minutes.
Is there any
Vitan Sulake is there. He has raised his hand. Shall I allow him to?
Please.
Not sure.
Yeah.
I have allowed him. He has to unmute.
I have already posted my question with anonymous name.
Can you just repeat it, please?
Okay, sir, I have prepared one design for a state government, center of a central design organization, Nasik. It is in the software. Now I have submitted a design, everything to the CDO for vetting. Now they are asking me to submit a soft copy of that, of which I am not interested in submitting that soft copy because it's my intellectual property. So if once I give it to CDO, means state government, they will start copying down. So how do I protect my interest now?
So have you written the whole thing?
Yeah, that's what. Yeah.
So then please put below for every paper that is going,
Okay.
for every paper, please put below a C and you circle that C.
Okay. Copyright. Okay.
And you write the year and you write author and you write your name.
Okay.
Okay.
Thank you, ma'am. I really enjoyed your lecture today. Really, I was not knowing many things. I am 70 years old. You see, I am retired executive engineer from CDO. I am a consulting engineer. I am designing dams and barrages, actually, all over the world, actually.
So
Does he have to apply for a copyright?
The one more, Mr. Grish is asking question. I am allowing him to speak.
Please allow.
Yeah, sure.
Mr. Girish, please go ahead.
Thank you, Uttam sir and the entire team. Ma'am, my question is this, which normally we do come across as consultants in our field. We develop drawings in stages. For example, we start with the master stage, then go with a further design stage, and then with a micro detailing stage. There are certain instances wherein the client, after stage 2, he suddenly takes away the entire set of drawings and enters it to some other consultant, albeit of a smaller firm or something, maybe from cost point of view or whatever, because he may not have to pay our third slab fees. So the master plan is ours, the broad spectrum of design is ours, but then when it goes on to the micro detailing, it has gone to some other people. So how do we protect ourselves against this, please?
So it's the same thing on your drawings. When you're doing the drawings, please write your copyright notice.
Okay.
You have to write your copyright notice, and please be very meticulous in noting down the details of when you are giving what, because everything can be then admitted as evidence that a certain copyright infringement has taken place.
Ma'am, what the client claims is he has paid us stage 1 fees and stage 2 fees. Therefore, whatever we have done on stage 1 and stage 2, it is his ownership, and he is free to do whatever he wants with stage 3, because 1 and 2 have been done, fees paid, but stage 3 is his prerogative. That is how he is trying to define it. That is his position.
Yeah, but then that depends upon the kind of contract you have entered with him.
Okay, there is no mention of any copyright there.
Yeah, no, and also the contract. See, copyright does not stand alone. Copyright always goes with the contract.
There's an interplay of things, yeah.
Yes, it has to be. So if you want that that they should also come to you from stage 3, then it is an engagement letter which you will have to give them. And the engagement letter should stipulate very clearly that, if you come for stage 1, then you will have to come for stage 2 and stage 3. Those are things you know better. I don't, but I'm just saying it has to stipulate very clearly how that has to be managed and how would you like it to be managed.
But just because that is not there, I am the author of the design. But going by what you said, am I not entitled to it because I am the originator?
No, this is, work for hire. Even if you're the originator, he is paying you for the work.
Okay. Right. Thank you, ma'am. Thank you.
There is no other raised hand, so
We could sum up.
yeah.
So while summing up whatever Anuradha has said today, the most important things being value of intangibles she has touched upon. We have noted that there are 2 types of assets, tangible and intangible property, that can be recognized and understood. That ideas and innovations too are also proprietary in nature. Secondly, we have touched upon various kinds of IPS, constitution of IPS, patents, trademarks, function of trademarks, copyrights, industrial design, trade secrets, IPR limits, limits of IPR, organizational assets, data as an asset, value of data, and various case laws on that. Probably we have covered the whole bunch of IP section topic today, and it was very informative and useful to all of us. Thank you, Anuradha, once again for your participation.
Thank you so much for giving me the chance to, speak before you all.
Yeah.
And I hope, at least there would be some understanding of
Lot of lessons learned.
Yeah, of IPR.
Yeah. Thanks once again. Mr. Mal, anything you want to say?
No, I think let Jeffrey give the vote of thanks and the concluding remarks.
Thank you, Mr. Mal. On behalf of CAI, we'd like to raise this vote of thanks. It should have been the privilege of Dr. Subbarao, but he was pulled away. He's on so many committees. He's our chairman, and he's on so many committees. Somebody else fixes the appointment. He is unable to control, so he apologizes for his absence. And on his behalf and on CAI's behalf, I have the privilege and honor to raise this vote of thanks. First of all, to Uttam Sengupta, because he brought us in touch with Madam Anuradha Maheshwari, and thanks to that coordination and advice from Uttam, we were able to receive such a beautiful, informative, and very objective lecture, in which even Dr. Pradhan gave us an overview of his experiences, how you can protect other people's software or the other people, a developer. Even if you're doing a project, you can ensure that they also take the benefit of it if you're using their product. So thanks to Dr. Pradhan, thanks to Uttam, and finally thanks to Madam. Madam, you really spoke so well.
Thank you so much.
Yes, thank you. From the interaction from the audience, we can really understand how you have reached out to everybody. You have brought a very difficult topic on board in a simple way. We understood the value of intellectual property and how to use this asset and bring the intangible, make it tangible, make it a property, and people can derive benefit. But ultimately, the onus is on the developer. That is clearly understood. If a developer wishes to protect it, then he has to make that effort to do all that, to protect his trademark, to protect his, his inventions or even data. Everything has, the onus is left on the developer. And unfortunately, as human nature you brought out is, we tend to steal. The basic human nature that we tend to steal. So one has to protect that. Thank you so much. And I thank our head office, Mr. Maini, for really organizing this webinar nicely and interacting very nicely. And even Sheena for developing the flyer. And ultimately, Mr. Mal for dotting every T and crossing every T and dotting every I. Mr. Mal really goes into a lot of pains. Thank you, Mr. Mal. I wish your internet improves so that we can also listen to you. And shall we close? Thanks for
Yes.
everything. And I
Thank
want
you,
to thank
Jay.
the participants. Thank you all the participants for coming on today, sparing your valuable time in the mid morning, and I hope you have derived the benefit. You can write to CI. You can even become members